A standard legal contract operates on a strict requirement of mutual consent. One party makes a specific offer, the other party accepts it, and the law enforces that agreement. This diagram shows the ultimate legal objective of that standard model, the orderly performance and discharge of mutual obligations. Both parties know exactly what they owe and what they are owed. But the Indian Contract Act recognizes specific anomalies. There are situations where mutual agreement doesn't exist, yet the law sinks in, forcing an obligation to pay based entirely on equity and fairness. There is a second anomaly, agreements that are perfectly formed but completely suspended. The obligation remains dormant until a completely unpredictable external future event actually occurs. Sections 31 through 72 of the Act lay out these exceptions. They form a strict algorithmic system designed to enforce fairness when mutual consent is absent, map out future uncertainty, and dictate the exact mechanical rules for how debt is discharged. This comparative matrix illustrates the first anomaly. A quasi-contract lacks prior offer or acceptance. These are legal fictions imposed entirely by the law on parties who never actually agreed to anything. The foundational philosophy driving this legal intervention is the prevention of unjust enrichment. If one person receives a tangible benefit at the expense of another, the law corrects the imbalance. Because there is no actual breach of a promise, the law places a strict limitation on the legal remedy. A plaintiff in a quasi-contract dispute can only sue for financial compensation to recover the specific monetary value. They can never extract punitive damages. We can see how this works across 5 specific scenarios, starting here with Section 68. If a supplier provides necessary goods to someone legally incompetent to contract, like a minor, the supplier recovers the cost from the minor's exclusive property, never from the individual directly. Under Section 69, if you pay another person's legal dues in good faith to protect your own financial interests, the law dictates that you are legally entitled to strict reimbursement from the party who originally owed the debt. Section 70 dictates that if you do something lawful for another person, you do not do it for free, and that person derives a benefit from your action, they must compensate you for the value of that act. Section 71 establishes that finding lost property does not grant ownership. It legally transforms the finder into a bailee, imposing a strict duty of care and a mandate to locate the original owner. Finally, Section 72 handles the math of mistaken payments. If 2 parties owe a single debt to a third party and one accidentally double pays, the receiving party is legally forced to return the excess funds. By enforcing these 5 sections, the legal system proves that objective fairness and the restoration of financial balance take priority over the strict requirement of a signed mutual agreement. This timeline path visualizes Section 31, the contingent contract. Here, performance is entirely dependent on a future uncertain event. Until that specific event occurs, the contract remains locked. The critical constraint for this framework is that the unpredictable event must be collateral. It must be a secondary variable attached to the agreement, not the primary performance itself. Sections 32 and 33 apply strict binary logic to this collateral event. Enforceability hinges entirely on whether the agreed condition was the happening or the non-happening of the event. If an event must happen and it becomes impossible, the path turns void. But Section 33 carries a specific exception. If a contract is predicated on an event not happening, the agreement becomes enforceable the exact moment the ship sinks, and return becomes scientifically impossible. Section 34 introduces human conduct into the logic. If a contingent event depends entirely on the actions of a specific person, the event becomes instantly legally impossible if that individual acts in a contrary manner. Section 35 applies fixed time limits to these contingencies. If the agreed event does not happen within the specified timeframe, the legal mechanism voids the contract entirely. And under Section 36, any contract tethered to an inherently impossible event, like 2 parallel lines intersecting or marrying a deceased person, is void from the absolute beginning, regardless of whether the parties knew it was impossible. Contingent contracts function as legal risk management algorithms. They allow businesses to lock in formal commitments while isolating their actual liability behind verifiable external logic gates. Once a standard contract is formed, or a contingent gate opens, Section 37 establishes the absolute baseline obligation. All parties must fully perform or formally offer to perform their promises to extinguish the contract. The law distinguishes between standard contractual duties, which pass to legal representatives upon a promisor's death, and contracts requiring unique personal skill, like a commissioned painting, which die immediately with the promisor. Sections 38 and 39 clarify that an unconditional, properly timed offer of performance completely shields the promisor from liability. If they show up ready to deliver the goods and the other party refuses to accept, the promisor is discharged. We see the true mathematical complexity of performance in sections 42 through 44, covering joint liabilities. This topology map shows a scenario where multiple individuals share a single contractual promise to a single promisee. The law arms the promisee with the rule of single compulsion. They hold the legal right to bypass collective demands entirely and extract 100% of the owed performance from any single joint promisor they choose. The targeted promisor is then protected by the contribution rule. They retain the legal right to force equal financial reimbursement from their co-promisors, ensuring the ultimate loss is shared evenly. If the promisee formally releases one promisor from the agreement, it does not dissolve the legal liability of the remaining joint promisors. They still owe the balance. These rules of performance are engineered to guarantee closure. Once liability is formalized, the legal system actively prevents parties from using collective finger-pointing or technical refusals to evade the final discharge of their debt. Sections 51 through 54 address reciprocal promises, where the legal obligation of one party is entirely sequenced and dependent on the readiness of the other. Neither side needs to perform unless the opposite party is ready and willing. Under Section 53, if one party actively sabotages or prevents the other from executing their specific sequence of its contract, the contract becomes voidable at the option of the prevented party. Section 57 establishes a boundary rule for mixed agreements. If a contract combines legal actions with illegal actions, only the legal portion survives judicial scrutiny. The illegal promises are voided entirely. This visualizes the financial mechanics of the appropriation of payments, covered in Sections 59 through 61. When a debtor owes multiple distinct debts to a single creditor, a specific hierarchy dictates how a payment is applied. Section 59 sets the primary rule. The debtor holds the supreme right to dictate exactly which debt their payment is applied against. The creditor must follow these instructions. Section 60 acts as the secondary fallback rule. If the debtor remains completely silent and specifies nothing, the legal power to allocate those funds transfers entirely to the creditor. The final statutory fallback is Section 61. If both parties fail to specify an allocation, the law mathematically applies the payment in strict chronological order, satisfying the oldest debts first. The Act abhors financial ambiguity. It provides a deterministic, three-tiered hierarchy to resolve payment disputes by prioritizing explicit intent first and chronological math second. This complete architecture places the three pillars of the Contract Act side by side. We have obligations imposed by law, obligations gated by events, and obligations discharged by performance. For exam preparation, the distinction regarding remedies is critical. Quasi-contracts grant compensation strictly to restore balance, while broken standard contracts yield damages for breach. For contingent contracts, the structural requirement remains absolute. The uncertain event must remain strictly collateral to the core promise, and the mechanics of joint liability dictate that promisees wield the power of single compulsion, forcing multiple promisors to rely on internal contribution rules to balance their own books. The Indian Contract Act of 1872 operates as a timeless, mathematically precise algorithm. It enforces fairness, calculates risk, and systematically resolves economic friction.